Good afternoon, everyone. You know what time it is, 4 p.m. Eastern Standard Time. It's Speaking Legally, where the legal meets the culture. Brought to you by the Destiny Designers TV network. We're here with our two expert attorneys and co-hosts, Royce Russell Esquire, Edward Pichardo Esquire. Thank you so much for tuning in, being a part of the show each and every week. I just ask you to go ahead and share the broadcast. If you have enjoyed the content, the information, and the resources that our expert attorneys share each and every week, don't be selfish. Share it out. Let folks get access to it because it can help them in a situation, and at the very least, give them two experts that they can contact when issues around criminal justice, around civic and civil issues, around immigration, around union. There's so many things that these two gentlemen can do for you, your family, and community. So with that, let me turn it over to them to say hello this afternoon. Mr. Russell, welcome to the show. Any opening words for our audience?
Let's get busy. Information is power, so let's give the power to the people.
Awesome. Senor Pichado, buenas tardes.
Buenas tardes. No, it's buenas tardes. Good afternoon.
I think
Hola todo el mundo.
Or something.
Hola nuestra comunidad. Poder a la gentes. Poder a la comunidad pa'lante. I say hello to everyone. Good afternoon. Thank you for joining us here today. As usual, I believe you're going to find the content and the discussion to be very helpful and fulfilling as well as educational. So welcome.
Absolutely. And we are well on our way in the second quarter of 2021, witnessing quite a bit in the news. You know, this is where the legal meets the cultural. So there are multiple things that are going on that we want to address. But one is an incident that not only gained quite a bit of media attention just because it was difficult to just even see the story of what happened in this particular instance. I'll play the video and then we'll talk about what is happening. There's no sound, but just pay close attention to what you see happening. Oh my goodness. This is hard to watch. So note the employees on the inside because that's what we're going to switch to talking about. So as we can see, the door was closed. Two other employees came out, and we can't see what's happening to the woman that was attacked at this point clearly. But now there's somebody exiting or planning to exit, and they're being stopped. And they open the door for that person to leave. So all of this is being captured on camera. Before we even get into what we're watching, I think everyone should realize that no matter where you are in America at this point, there are cameras. So, you know, don't be so bold to think that things won't be captured. And now somebody else is coming inside of the hotel. So this is interesting. All of this is going on while there's somebody outside. Now, afterwards, apparently, it looks like they're exiting the hotel to see what the state of the victim is. So I know this has caused quite a bit of conversation culturally. There's been a lot of press conferences and information about what happened and standing with the Asian community in New York. So the doorman that you saw close that door has subsequently been fired for not helping the woman that was beaten. So I'm going to turn it over to our attorneys because there are layers to this conversation. Who wants to start first? Mr. Pichardo?
Sure. I just really want to start out by saying that the violence that I've been witnessing against our Asian brothers and sisters, I have found to be absolutely abhorrent and intolerable. I don't condone violence against any human being, but especially when the motivation is the person's ethnicity, their race, their national origin, religion, gender, sexual orientation. When you're choosing to commit violence against someone because of who they are, who you perceive them to be, I find that just absolutely abhorrent. So let me start out with that, and that I stand with my Asian brothers and sisters against all levels of racism and violence that's being leveled against them. That being said, the reason why we found this topic to be of interest here is because for many years I defended workers in labor arbitrations. And so let me get to the point here. Basically, these two individuals belong to a union, 32BJ, which is the major union in New York City and actually throughout the country that represents, janitors, security personnel in buildings like this and concierges. And my understanding is that the owner of this building is the Brodsky organization. They are a huge realty company that owns a lot of these luxury upmarket buildings throughout the city, and especially in Manhattan. I believe this happened somewhere in the 40s on the West Side in Hell's Kitchen. Now, these workers, just thinking this through, I got a feeling that these individuals found themselves in a real tense situation because they are employees. Their job is to serve the residents of that building upon entry, upon exit, etc., maintaining security there in front. And so the question becomes whether or not they were even authorized under the rules that they operate in as an employees to leave the property and intervene in an incident that's occurring outside. What if they would have come outside and then gotten into an altercation with this individual? Would the employer have then said, hey, listen, you left your post unattended? Or let's paint another scenario where the altercation occurs, something happens, and this individual later sues the building because they say, listen, one of your employees hurt me, committed a tort against me. Any number of scenarios can occur where this individual, this employee, is now in a position of having to defend themselves against disciplinary action for intervening against the rules. Now, in all fairness to the employer here, they're saying that, and I'm still waiting for all of the facts here, that something about that at the very least they should have immediately called 911, which most people would find reasonable. But then again, I'm also hearing that they did do that, but maybe they didn't do that quick enough or quickly enough. Early on in this story, the focus was on the employee closing the door and not coming out to help in that. But the extended video that you're showing here today, Dr. Grant, is a video they came out after the first initial video showing these employees actually later on opening the door to see what was happening out there. And my understanding is that they did offer some assistance later. And, there are differing opinions here. Some folks said, listen, at the very least, you should have come out and said something. Apparently, there were some bystanders in the area who were shouting at this gentleman. So I'm going to stop there before I start talking about what I think the union that represents these employees is actually going to do to address this firing or disciplinary action by the employer.
Well, based upon what I've heard you say so far and what I've seen, to me, it is basically damned if you do, damned if you don't, catch-22 situation for the employee. We first started out talking about this in the realm or the forum of it being an arbitration. And so let me just define what arbitration is, and then we'll get back to the facts. Arbitration is not a trial before a judge. It is not a trial before jurors. You're not going to have 6 or 12 people hear your case and come to a decision. It's going to be one person, or it might be a 3-panel or 5-panel arbitration board that will hear the facts of what took place and make a determination whether or not you should keep your job or whether or not you should be terminated. And that's important because when you have one or two minds or three minds deciding a situation versus a jury of your peers, that makes all the difference in the world. So that's one. Two, in arbitration, the rules are a little bit more relaxed than in court. So a lot of information can come in that wouldn't necessarily come in a case that's before a jury. And the arbitrator, who's presiding over the case, if it is a one-person arbitrator, decides what happens and what doesn't happen, what evidence comes into play, and what evidence is precluded, like a judge, and what that person wants to see or not. And that's important because I don't think anybody comes to any job free of human life experiences that they have had personally or they have witnessed. And so when you pick an arbitrator, and if I am correct, the parties will choose an arbitrator. It will be a mutual person, or there is someone that the union and that the employees regularly, the union and the employer regularly use, and therefore they may have a rotation of arbitrators that may hear this matter. And so there may be some history, and the union reps might know what type of arbitrator this person is. Nonetheless, I'll circle back to the catch-22. As you rightfully stated, Ed, and I'll just put a little bit more light on it, is that if we take the scenario that the employee goes out and he protects or tries to intervene, can't necessarily say protect, tries to intervene, and the assailant has a gun or has a knife and he's stabbed and he's injured, you know, and I know that the employer is going to say, maybe you get workers' comp, maybe, depending upon what your job responsibilities and duties are. It doesn't include going out the building to a non-tenant, maybe. We haven't heard whether the person was a tenant or not, to a non-tenant, and to go out on the street 10, 5, 15 feet in front of the premises. So you might get workers' compensation. If the employee sues the employer is immediately going to say, that's not in your scope of duty. You don't have a duty to go outside to bystanders, to strangers, even if it's happening in front of our complex. So I'm sure as that employee making a little bit above minimum wage, might be making a good dollar or not, has to make a business decision versus a humanity decision as to what he wants to do and how he is going to proceed. Now,
and I'm sorry, and I will add, listen, I wouldn't be surprised if these employees had experienced something similar, but not to this degree in some other instance, and say, hey, listen, the last time I dealt with something that happened outside that door, I got a warning, I got disciplined, I was told that what goes on outside these doors, is none of my business. I mean, I just wouldn't be surprised, especially if, you know, like you said, you mentioned the issue of a non-resident, that's big here. I mean, one of the things I wanted to expand upon was, and I should have talked about this somewhat, is I completely agree with my colleague, but I would add further. What happens here is that the union and the employer, in this case, the building owner Brodsky, they come to an agreement on a labor contract, and that labor contract usually has a provision for arbitrations in the event of some sort of disciplinary action. And as Royce said, it could be a panel that hears the case. It could be a certain set of arbitrators that the parties agree to. From what I recall from my experience from one of these 32 BJ arbitrations having to do with some building personnel, I believe they actually use the American Arbitration Association.
Okay,
that's a
reputable association where you
they basically have, I think they have maybe a couple of hundred arbitrators that the parties not so much select, but they put in the request, and there's like some sort of rotation system that's used. Right. A certain group of arbitrators come out of that, and then the parties kind of agree, okay, out of those 5 that came up in the rotation, we agree to use these individuals or this individual. Yeah. And it's usually one arbitrator. And as Roy said, the rules of evidence are relaxed. However, listen, some more aggressive attorneys, and I would say that I was a bit aggressive in my time in these arbitrations. I would go every inch when it came to the rules of evidence to stop any sort of evidence that I found to be prejudicial to my worker from coming in. I would request a sequestration order at the very beginning, because sometimes the employer would try to come in and sit in the room while we're doing openings or talking about the case generally with somebody that was going to testify later. And I would be like, why is this person here? And you got to raise that stuff early on, because if not, you might waive it and say, well, you allowed him to sit here all this time. Why are you bringing it up now? And I would say, no, that person is going to testify. They got to be outside of the room, because they don't need to be hearing anything regarding, what the case is about, and trying to formulate their testimony and couch it to fit within what they heard already. So, and then in terms of the documentary evidence, in a case like this, I would imagine the rules and procedures are going to come in, the ones that each party wants the arbitrator to focus in on.
But the video will speak for itself, in essence, of really determining what happened, right? And the only thing that any side really has is the prior history of that employee. But the real issue is what is this employee supposed to do? Because I am almost sure, that there isn't an insurance plan that takes care of the employee once he leaves the premises or intervene. If they were selling drugs out there, the employee would not go out there and tell the drug dealers, yo, you can't sell drugs out here. Are you kidding me? Now, this is where the cultural and the political correctness in the media can sway someone to make a bad decision. It is because of all these pressures, rightfully or wrongfully, that this employer, to me, this is my opinion, allegedly, this is the motivation for the termination. Now, yes, could have ran out there sooner, probably so. Didn't know maybe whether or not the person that committed the act is still out there. But if that employer would be able to stand up and say, no matter what, we would have reimbursed that family had he been shot in the head, had he been stabbed. We would have reimbursed that family for future earnings if he was paralyzed by what the assailant did.
That's a lot.
It is a lot. It is a lot. And so this is what we call the peekaboo. It's called the peekaboo. I'm a peek to see what happened. Oh, I see what happened. All right. And I see what the media is saying, and I see what's going on. So let me step out here and let me make this statement. The boo is that when someone like Ed or myself who's representing the employee says, well, what does the employee handbook say? What does it say about risking one's life and limbs outside? Now, this moves us away from whether this is a hate crime and what happened to that person, because we're talking the legal aspect. We're introducing the concept of arbitration. What does it mean to go to arbitration, and how someone from a cultural standpoint, it is probably likely that this person is a person of color that had this position as the doorman, how this is affecting someone who just wanted to go to work that day.
No, and listen, your point on the workers' compensation is monumental here, because workers' compensation is for on-the-job injuries, and
it makes it seem like this is on the job, right?
And in many instances, location is everything, because if you go off premises and you get injured, employers don't hesitate to raise that on-the-job portion of the law, whether this was in the course of your employment, which then gets connected to the scope of your employment. Was within the scope? And listen, I could see this going. What they say, going left very, very quickly.
So
and
hold on, and before it goes left, I just want to say hi to Deborah and Dr. Karen Champion for being here on the show. Karen had a question, so I want us to address that. She said, "Where's the voice of the union for the doorman? I don't think he should be fired on this basis.
No. Listen, Kyle. From that article right there, in fact, Kyle Bragg, now the head of 32BJ. My understanding is he's coming out and to say that they are defending these workers, and like I mentioned earlier, the very first video from the best of my recollection was the short snippet of the doorman closing the door, and they didn't show the extended version of the workers later on, opening the door and I believe going outside and offering some aid and assistance.
And let me interrupt you. Let me stop you there and take this into consideration as you go through your analysis, right? And what you depicted in the video. Let's just say that the doorman did exactly what he did. He didn't go outside. And the guy came inside. Then where would we be? He still would be fired, right? How did the guy get inside? And he hurt someone inside. The first thing the employer would say is, why didn't you close the door?
Listen.
Protect the residents. Why you let them in?
And if you notice, too, there was one resident who comes out, and I think it looks like it's a female, and comes in, and then I see another white male come in real quick, and them, closing the door and so forth. I mean,
or if a resident was coming to the building, saw this happen, and the security guard kept the door closed, that resident would be banging on that door like, let me in. So
don't you see what's going on out here?
Right. So I don't see how this employee can win in this situation. But this is what happens when, unfortunately, things are played out in the media and you have knee-jerk reactions for the sake of having a reaction and not really thinking it through.
And just to let folks know, I represented the workers of the Transport Workers Union, Local 100, for many years. And they would find themselves in these strange situations where station agents sitting in the booth, something is happening outside of the booth. Do you come out the booth? Do you stay in the booth? What do you do? You're supposed to be protecting that revenue, that money. Oh, you stepped out of the booth. Why did you step out of that booth? That's not your job. You got bus operators. Something is happening on the bus. What do? Do you get up out that seat and intervene? People get attacked on that bus all the damn time, from young children to old folks to,
And if the bus drivers I know who've also been attacked, they ain't jumping up.
Oh man, I represented brothers who got stabbed with pencils in their temple, attacked, punched, get into altercations with passengers, get written up, get arrested after the passenger hit them first, spit on them. Ooh, COVID. Baby. Let's talk about that.
It is not a situation that I think is someone to put in so many variables. That's right. And none of the variables are fixed. All of them are very fluid.
Very fluid in management.
Happening very quickly to a degree as far as what your mental makeup is. Now, look, everyone loves a hero. Everyone loves a hero. But in the instance that person's a hero, and this is the wildest scenario that could happen from this, but it's not too far from reality in some sense. The employer goes out, he subdues the assailant, and in doing so, he breaks the assailant limbs, arms, does something. Mm-hmm. Nothing stopping that assailant from suing the building and that employer.
That's right.
For using too much force. And we think about this concept of excessive force and from a police perspective. But if I know Taekwondo, Jiu-Jitsu, or whatever, and I'm the security guard, or I'm a boxer, and I come out and I see this happening, and I subdue this guy, and I break his ribs, or fracture his hand, or dislocate something, there's nothing to say that he can't sue me and the employer of the building.
Yep.
Why didn't you call the police? So it'll be a shame if this is the only article that sees the light of day, because this is an interesting and a very realistic cultural and life
Yeah.
life experience type of moment in the legal arena, and I want to hear more stories about it. But
Yeah, we have more to talk about, but to your point, we have a lot of people in our community that have jobs just like this gentleman, and like you said, it can go so many different ways. I'm just curious as we now move into what's prevalent in the news with another cultural aspect to a case that we all know about, unfortunately. If it does go to the point where that person gets sued, just in the example that you used, Mr. Russell, what's the chances of that person winning a lawsuit like that?
it all depends on the nature of the injuries. I mean, he's being charged criminally. That's mutually exclusive, right? So the police, if he was captured, the police will handle the criminal part. He's not benefiting necessarily from the criminal act to a degree. I mean, there may be some issues, Son of Sam laws that says that you can't benefit from criminal acts. That means write a book. However, if he's injured by the employee of a building, why not? You got nothing. Look, if I'm going to do some time, I ain't got nothing but time. And so,
And as we say in Spanish, mucha de esta gente son unos freco. Freco means atrevido. It means people who just don't care. They don't care how it looks. I could see one of these types of folks suing anyway, not caring how it looks to the general public.
Clearly they wouldn't care how it looks if they're taking the woman in the chest and the street. Right. So I'm with you.
We got certain phrases for these types of people in Spanish. There's some very colorful ones, for individuals who act with no shame at all in their game, and because this individual that attacked this woman, man, he needs to be put under the jail. I heard he spent years in prisons for killing his own mom. I mean,
what?
Yeah,
right.
man.
And so this is the tall task that we're asking an employee who knows nothing about another individual to jump out and do something. And I know, well, put it like this, I surmise, right, because I don't know but so much, that the employer and the employee handbook does not cover what we've just discussed.
Yeah,
exactly.
And Richard said, "Hey, Richard, I agree. So many moving parts." Rolanda says so many variables, and I think Dr. Champion, you said the same thing. The parameters that the person has to work with. People are scared today, even when they want to help out, but self-preservation comes first because of the after effect and repercussion. That's the facts and the reality. So it's a lot that plays out in the media, and I don't think it's always balanced with that reality that we're living in some interesting times, and jumping in could jeopardize more than one person's life. So
and nothing like some repercussions, especially if you want my cornbread, because I'm telling you right now, repercussions is something. You know what I mean? That's the correct word. Repercussions. That is definitely the correct word.
But here we are dealing with in real time what we see transpiring in the case of Derek Chauvin and George Floyd's murder. So we touched on some of what we saw happening last week. The trial is literally going on now. There's more testimony happening. We're just going to listen in for a little bit and then share our comments.
And so, Your Honor, just to be clear, what we initially offered as Exhibit 54 will actually be Exhibit 53. And we will, for clarity, offer Exhibits 53, 54, and 55.
Any objection to any of those? 53, 54, and 55 are received.
I don't intend to publish them at this time, Your Honor.
Okay. Anything that was not received is received or unpublished. Which one are you going to publish?
We are not going to publish them.
Not going to. Okay. Thank you.
This witness looks very distressed.
Well, a little bit of that witness background. He's a special agent assigned to this case, and he started his career at 32nd Precinct in Harlem. And there's something to be said about that. I'm surprised that defense counsel did not use that in his repertoire of taking a little chunk out of his credibility in reference to what took place concerning George Floyd. And his mistake, our victory. I think this witness was very, very good in some of the things, or helpful to the prosecution in some of the things he said. But I take the time to speak now because defense counsel, throughout dealing with the expert, was a little delayed in getting to the punch.
Mm.
Let's see what he tries to set up if we can get to it.
Mm-hmm.
Your Honor, I am requesting permission to publish a portion of Exhibit 55.
His facial
Your Honor,
expressions.
You have had an opportunity to review the Dragon Walk surveillance video.
Yes, sir.
And there are portions of the video where Mr. Floyd is present, correct?
Yes, sir.
And it shows various interactions. But after Mr. Floyd leaves, there are interactions between other people walking past. The camera continues to run the same perspective.
Correct.
Your Honor, I would ask for permission to publish Exhibit 55 starting at the timestamp 203848. And Agent Ryerson, I'm going to ask you to watch the area of the vehicle and the passengers in the vehicles.
Yes, sir.
Are you able to see?
Yes, sir.
What does it appear that individual does?
Individual in the red hat you're referring to
Yes.
appears as though he throws something.
So he's looking initially through the passenger or through the vehicle, looking in the area of the police officers, correct?
Appeared that way.
It appears that he then reaches into his backpack and retrieves something,
Yes,
and it appears that he then throws it off to his right shoulder, right?
that's correct.
And it appeared to go some distance away.
Yes, sir.
Would that be consistent with someone trying to get rid of something that they don't want the police to find?
Could be yes.
I have no further questions.
All right, so I just have to put perspective in reference to witnesses that came before and this witness. There was a Sergeant, I think it's Siger was his name, or Siger, Siger. And he came on today. He testified today as an expert in use of force out of California, laid out his credentials. And one of the things that they were trying to establish today was that Mr. Floyd died of cardiopulmonary arrest and fixation based upon the pressure versus fixation based upon the drugs that he took, one being fentanyl. And so I'm looking at my notes because I took a lot of notes down. There was a much to do as to whether or not the knee was on the shoulder or on the neck. It's to be projected and expected that the ME examination coroner's report will show that there was bruises on the shoulder and there was no bruises on the neck. We're starting to get into the technical part, but really the most important part of this trial, where reports are taken apart piece by piece, and all the things that you heard defense counsel say and lay down, such as when he was cross-examining not only this expert or lead investigator, as well as the sergeant, both people of color, he kept on reinforcing and using the word a reasonable use of force, reasonable police officer. One of the words he said was that there are tactics that are used that every state is not uniform in how they use those tactics, which is correct. Implementation differs. He even spouted Graham v. Connors, which is the case that sets the groundwork for use of force. And he was able to get out of the expert how reasonable minds can differ. Now, we have to put that in perspective. What is he trying to set the table for? When you say reasonable minds can differ, the assumption is that Chauvin is reasonable and that the expert is reasonable. And we could differ as to how things should be done in a reasonable way, because reasonableness is what is the linchpin to most of the charges.
Beyond a reasonable doubt.
Well, not necessarily beyond. Was the force reasonable? Was the force depraved? And if you're reasonable, then you're not depraved, because depraved means that you don't care. You're unreasonable. You just want to do what you want to do. So defense counsel was able to throw the language in the reasonable and reasonable and reasonable throughout his cross-examination. I will tell you right now, and you know this, Ed, is that what makes a witness is not the direct examination where I'm asking you questions because I'm a friendly face. We prep before. You know the questions I'm going to ask.
It's the cross.
It's the cross-examination.
Yeah, that's the that's the defense attorney's bread and butter, breaking down that witness,
That's
making your points.
That's
He-
the stress test.
During his opening, he made it clear he was going to attack causation, which is what I think the bruises to the shoulder blades versus the neck. That's where it comes in, because his intent is definitely to attack, not only the method, because when this case first came on the scene, I actually did some research in terms of this restraining technique. And unfortunately, I think there's some publications out there that, allow for this technique to be used with the knee being placed on the shoulder blade.
Right.
Or the back and not the neck.
Right.
And so it looks like he's going to definitely attack causation. That's become clear. It looks like they're going to be at some point presenting their own expert.
Well, yeah,
This
is going to be a trial. Well, put it like this: I think the prosecution has done themselves a disservice to try this case as a traditional case, where you put on witnesses to kind of build the story of what happened, and then you put on experts on the back end to talk about the causation. And I think that traditional way of trying the case is going to lead them to a place that they don't want to be, because we know Floyd had the underlying conditions. And I'm spending time talking about defense because it's easy to talk about the prosecution. It's gravy. It's gravy on some good grits. The grits are already good, and you putting some gravy on it. That's what it is. It's
what happened to the fish?
Grit, right?
Yeah, I'm like, wait, how we get the grits? It's where the legal meets the cultural.
Oh, man.
So talking about defense is the hard part, right? And the hard part is when your mother told you, I told you to come downstairs and the grits are cold and you can't reheat them. She like, no, you got to eat it like that. I told you to come downstairs. There it is. And you hoping the gravy's hot.
And the jury already heard it, right?
And the jury already heard it. And meanwhile, your brothers and sisters are already licking their lips and eating at the table, and you last to come. And so this is what I'm talking about, the last to come, because no one likes cold grits. And no one likes to hear that Floyd had high blood pressure and he had a large heart and he had ingested drugs. No one likes to hear that. But we have to hear that if we want to understand where the defense counsel is going and how we see, quote unquote, those that are not in line with us, how we see what they see and why they see it. So when you talk about compression versus cardiopulmonary arrest and whether it was drugs that caused this, and one pivotal moment, and I don't know why prosecution didn't jump up and basically like make a scene or do a quick sidebar, is that when the sergeant was testifying, there was a moment where Floyd had said something and he had asked the sergeant, can you make out what he said? The sergeant said no. That's it. You don't get no more bites at the apple. But the prosecution let him say, would it be fair to say, let's listen to it one more time. Would it be fair to say that he said, I took too much drugs? I took too much drugs while he was on the ground. Now, what the prosecution tried to do is that when this officer that we just saw here, the lead investigator, he said that Floyd said, I didn't take any drugs. Now here we are. We don't even have to be in this area right here. It's like Sesame Street. Follow the bouncing ball. Don't let it bounce to the left or to the right. Just follow the bouncing ball.
So with that, Reverend Miller has a question. Mr. Russell, what have been your preferred approach instead of the traditional approach taken by the prosecution?
So the secret sauce says that you start with all the boilerplate bland material. You start with the experts. You start with the cause of death. You start with the differences of opinion. You start with that. And when you say, why, Mr. Russell? Why would you do it in an untraditional way like that? Because if you're trying to show George Floyd as a human, which we know he is, a brother of all brothers, a brother from a different mother, then you want those other witnesses at the end that humanizes him. The EMT, the fire person that was trying to give him help, but that was denied. The brother that Mr. McMillan, who was shaking his head, who was crying, who was saying, you're not going to win. You want that at the very end. And the reason why you want that at the very end, and I know the court would tell the jury this all day and all night, sympathy should not play a role. I'm not looking for sympathy, but I'm going to take all these abstract things that we've been talking about in the beginning, and now I'm going to humanize them at the end. I'm not going to allow you to talk about him as if he is far away at the end. So now I got to remember, folks got short memories. So now I got to ask for readback of the 17-year-old kid or the 9-year-old kid or the minors that saw it. I got to ask readback. Hey, reading and seeing is two different things. I'd rather you have readback of what the ME and the experts said that happened 3 weeks ago, 4 weeks ago, 5 weeks ago, 6 weeks ago.
I tend to agree with you, Royce. I mean, even though sympathy is not supposed to play a role, at the end of the day, we're dealing with human beings. The jurors are human beings. The victim was a human being, you know, and people are, and like you said, memory is short. You know, it's just human nature. What is going to impact you the most is what you last heard,
without a question.
And that's and the impression, as Rolando Lamar, I guess, is stating here, that very last impression is very influential upon that juror. You know, so you know the emotional testimony, the testimony that humanized George Floyd, it would be more and more impactful if it was presented right before the closing statements and those jurors go to deliberate.
So now you take what you just said, Ed, and now we have these experts and they talk about, oh, well, you know, he had high blood pressure, he had drugs, and he said, I took too much drugs. And now you go back to the video in the store and you ask the layperson, the kid that was in the store, you saw Mr. Floyd, how did he look? Well, he looked kind of slow, he looking lethargic. Well, if you're slow and lethargic and you took drugs, that means you are less of a threat, right? You go back and you say, does that look like someone that's on drugs that's standing there? Now you have to reel the memory and you got to reel it back for somebody, or do you show the tape all over again and try to make your point? I just think that we're in a space and time in our life that we know the methods that haven't worked for us in the past. You know how many officers have been acquitted using this traditional way of prosecuting cases? I don't have enough fingers and toes to even give you how many have walked out those doors because we've used, or folks in charge have used traditional ways. I don't want to charge that charge because it doesn't neatly fit in what we're trying to do. No, you charge everything. You let the grand jury do their work. You know, I mean, we are in unconventional times. We have to change the way we do. And so, although I think he's going to be convicted, and I want him to be convicted, I'll let you know that now. If you ever put me on the show, I'll say that he's going to be convicted. I want him to be convicted, but we need to learn how we go about doing that.
And I think that's the key point. That's the key point that you're making, Mr. Russell, because we've watched this movie so many times. And that's why, in addition to the trial and the height of listening to the testimonies and what's happening, there is a great concern on the reaction to what happens with the result of this trial. There wouldn't be this concern if you didn't know that things haven't gone right time and time again. So if this, with everything that we witnessed, everything that we've seen, and if an acquittal comes out of this, dear Lord, like I just,
Dr. Grant, one of the things that happened today was defense was able to get out from the experts, and this is why you want to upfront this. He got out from one of the experts ways that you could use force. One of them is that you can tase a person when they're resisting. And the expert had no choice but to answer it the way he answered it. He said, isn't it a fact that with Floyd resisting in the van, that Officer Chauvin could have tased him? And it would have been appropriate. And Sergeant had no choice. He's the expert. He's the use of force expert. He had to say yes. And so then he went back and said, so the fact that Chauvin didn't tase him was showing that he was being reasonable. What are you going to say then? He's stuck in the bucket. He had to say yes. So he didn't use force when he could have used force. He de-escalated when it was an opportunity to de-escalate it. Nobody wants to hear those words. So now imagine if the trial ended today. Where would we be? That's why you got to front load this stuff. Get it out. Get it out in the open and run with your star player at the end. I mean, look, I'll make the analogy look like with basketball. You see all these basketball players hurt. Kevin Durant, Davis, Anthony Davis, LeBron James. When you're that type of level of a superstar and you have a certain age, guess what? You don't even play the first half. Don't even play the first half. Come in and play the second half on. And I bet you still you have longevity and you win just as much of games, if not more.
I don't know about you, Royce, but one of the things that's puzzling me a little bit about this case and the questioning of the witnesses when it comes to what they're seeing in these videos is I'm hearing witnesses stating that they're seeing or attesting to certain things in this video that I'm not necessarily seeing, like, or can immediately draw an objection that the video speaks for itself, and
a lot of leeway.
Yeah, like because like for instance, the part about George Floyd being combative inside of the car, there's no video of what exactly is taking place inside of that car that I have yet to see. I see the outside of the car and the car kind of moving for whatever reason, which at the end of the day to me is an assumption. The only people that can necessarily speak to what was occurring maybe were the officers who were involved and had a direct eyesight view inside. But then the question becomes, well, if you didn't have your body camera exactly on at that particular time, then you need to explain why not and why we don't have a video of exactly that. But I hear kind of some assuming going on, like what you played just now. They asked the witness, well, this witness was looking out at the cops. I didn't see that in the video. How do you get that from that video that guy is looking across the street? I mean,
what's more relevant and important is that he makes the assertion with no objection that, and the video speaks for itself, that he threw this object and that he was throwing that object at the police to set the scenario that the crowd was unruly, when the video speaks for itself. Sometimes you have to be what I call the Jedi mind trick. You don't have to speak to everything. Everything doesn't warrant a comment, at least not at the moment. It doesn't warrant a comment. So you let the person say what they're going to say, and you don't need to have a witness up there to counter it. So he says there's a crowd. All right, that's what you said. I don't need to bring another witness to say it's not a crowd. What I do is play the video, and I ask the jurors, do you see a crowd? He brought witness A. Is there a crowd there? Are they unruly? Or do you see cups being thrown? Because you guys don't know this, but one of the witnesses today, this expert again, said that one of the assessments of threats is language. And there were people cursing, and there were people yelling. And that's part of the assessment of whether there's a threat. Once again, I'm focusing purely on defense in our segment here, because like I said, it's easy to focus on the ice cream. It's easy. You know what I mean? I'm focusing on the other things that is really, really the fact that after I eat this ice cream, I'm lactose intolerant. That's what I'm focused on, the after effect.
Oh boy,
I'm focused on, right?
that's where the legal pizza
So-
culture
so
goes left.
that's what it is. That's what it is. It's nice to have it, but what happens after? And so I'm looking at the defense from that perspective, because you're getting things from a witness that I called to the stand. I asked you to be my boy. I asked you to be my best friend at my best man at my wedding. And when they say, "Well, anybody got anything to say?" You clearing your throat? No, that's not supposed to happen that way. You here for me. So you have to personalize those witnesses and have that understanding that they're there for you. And so when you hear stuff like this, like, oh, there was somebody throwing something, there was, vulgar language. And it really speaks to what a lot of people are not talking about in these legal commentators and analysts. And I don't know, well, I'm not going to say why they're not talking about it. I'm just going to give you my opinion, which is that no one is speaking to the over policing of our communities. And that's how we get to where we are. Somebody with a fake $20 bill, you sending 3 and 4 patrol cars?
Mm-hmm.
Like somebody's playing music too loud, and now you got the block squared off. This is because it's a high crime area. Well, are you called in for some criminal activity that warrants that? But you come in with the aggression. You come in with the cowboy. You come in riding on your horse sideways, swinging, coming in really hard, ready to land and pounce. And what happens? You land and pounce it. If you don't, you come in with the perception that I'm in the land and the area of pouncing. So if anything goes on, if the crowd seems to disagree with me, oh, I better act this way because I got to get control. And now you're even more aggressive.
And it's true. The over policing is a conversation that's not being raised as globally as it should. I mean, even in my own block, I hear 3-4 cop cars screeching, and literally it was my neighbor's son in his car, and they cornered him right at the corner of the block. And I came outside when I noticed it was him, and I'm like, they have their guns drawn, they're standing there, and I'm like, what could he have done? They said he was speeding, and one cop looked at me and said, "Oh, Miss," I said, "No, I'm not going anywhere. I live here, and his parents are not home. This is a young man." And so the mayor looked at me. I said, "I know my rights, and I'm not going to stand here as a mother and have you handle this young man this way." I'm calling, and I started calling her as I was standing there. And then one cop came over and said, "Look, this young man was speeding. We were following him." I said, "Officer, I'm not here to get into why you thought he was somebody or a person of interest. What I'm saying is it doesn't require all of this for the investigation to happen." And I know that was a chance that I was taking, but that was my maternal instinct. I was like, where are all these cop cars coming?
And
Because
Dr. Grant, if you start from that premise, understanding this case, and this is where the cultural comes in, because there's nobody on the team that has that. If you start on the premise, as Rolanda said, adrenaline, if you start on the premise that I'm coming in with the adrenaline, I'm coming in, I heard noises. I think my daughter got a guy upstairs. I better come in. You coming in with that into your house. You coming in with the motive operandi that you're gonna bust somebody, that you're gonna see something, that that number really is. That's the mental makeup for which you arrive at the place decides what you do.
Several months ago,
and because they don't think of us as human beings, more as property. That mental makeup allows you to have your hand in your pocket as your knee is on somebody's throat. No,
I just want to remind some of our more steadier audience members, about some months back, we showed a video of a guy running from the cops, getting inside of this car, and then attempting to run one of them over.
Oh yes.
We showed another video
Mm-hmm.
of someone who appeared to be of European ancestry screaming at a cop and raising his hand in that police officer's face, and both individuals got away with no criminal consequences, no charges, no violence, no nothing
in their life. Yep.
Okay, that's what this discussion reminds me of. Eric Garner was accused of selling illegal cigarettes, okay? Sticks that people use filled with tobacco to smoke, that at best was some sort of property tax offense. You're selling products and you're not paying the government their due taxes. What the hell is this? This gentleman buys, in this instance, I believe it was some cigarettes with what they thought was a fake $20 bill that some other retailer may have given him, and that he happened to be using without knowing that it was an illegal or a false $20 bill. So you have black people ultimately losing their lives for what start out as property offenses. You just talked about a young man committing a vehicle and traffic law infraction by speeding and is now being surrounded by officers with their guns drawn. This is a direct example of over-policing,
This is Malcolm X all over again.
of colonialism, of the siege of communities of color by law enforcement. You have then the flipping of the conversation to, oh, you want to eliminate the police, and where's going to be the security then? And then you have this twisting of the conversation from over-policing to none at all, no security at all now, no police now. That's what you're saying now? No, that's not what I'm saying either. I'm just saying I don't want to be getting beat up and killed by the police that my tax dollars pay for. How about that?
Dr. Grant, well, let me just say one more thing, which I think is critical. I want our audience to hear this and hear it loud and clear. I know we had shirts with Eric Garner said, "I can't breathe." And I know that is to remind us of a place and a space that we never want to be at. But to a certain degree, it's become a little bit of a tagline. It's almost like when the police say, "Stop resisting," when they know you're not resisting, but they're still beating you. I think it is my opinion, only my opinion, that when police officers hear, and it's totally wrong, you saying, "I can't breathe," they're like, "Man, please." I've seen that on a t-shirt. I heard that before. And they keep on doing what they're doing. And that's exactly here. They keep on doing what they're doing. Like as if you saying, "I can't breathe" is like you saying, Jordan for 3 or something that's like almost irrelevant. And so I don't want us to ever use that tagline in light, because it is like hitting a fire extinguisher, hitting for the fire extinguisher because is an emergency. And that's just my personal belief when I see this go on this way.
So we can be here for a couple more hours on this. And Dr. Champion says disparity within culture exists. Why doesn't the prosecution not bring up that Chauvin worked at the same club with Floyd and may have had a grudge from that aspect? So there are many, it could be a vendetta. And Reverend Miller says we need to revisit the conversation around over-policing to determine how we develop partnerships and change the culture within our community. There is more work to be done. And once again, we've said it on the show before, we'll say it again. We're not anti-law enforcement that does their job right. We're anti those who abuse the job and don't respect the lives of each community, because we've seen it. We played it on the show. What has happened that people walked away that didn't have black and brown skin alive after daggone they're attacking the police. But when things happen to us, our lives aren't valued. And that's where the conversation comes up. So we can't solve all the world's problems in one show, 4 p.m. every Wednesday, but we can raise the consciousness of conversation. We can push for the litigation of those cases where our rights are in jeopardy. And we can also press for the lobbying of changing of these laws so that we can have a more responsible response to what happens to people of color. This case is going to be a game changer for the good or for the worse. We're going to see it play out, and we are living history in this moment. I just pray that everything happens on the side of justice so that we can actually see us move closer towards the dream that Dr. Martin Luther King dreamed about, to what Malcolm said, to every one of our ancestors that are looking down and watching what's happening, we can only hope and keep hope alive that we will see that change happen. So as we close out the show, any last comments from our co-hosts? And thank you to everyone who tuned in: Richard, Rolanda, Reverend Miller, Dr. Champion. We appreciate you being here. Carol, we thank you for tuning in today. And Deborah, we thank all of you who tune in, who share this broadcast, and give us your feedback, because this is about our community, how we address the issues that affect us, and have the resources, information, and legal experts that can guide you down the path. So, Senor Pichardo, final words?
I say to all my brothers and sisters, stay clear-eyed. Look at all of these events and these incidents and keep your eyes clear and really use your mind and become leaders in terms of your thoughts about all of this. Continue to educate yourselves. Stay clear-minded. Peace.
I would add to that, here's a little takeaway for all our listeners. And so, because this conversation is going to go on, as long as this trial is going on, you can meet us here, same time, same bad channel, and we will have some discussion devoted to this trial. Look up Graham v. Connor, Graham versus Connor, use of force. So you can understand the definition and the prongs for which certain type of force can be used. And so we could become more engaged and more educated, and we can educate others when we hear and see the clear violations that are taking place in our community. Graham v. Connor, use of force. And with that, I'm out.
Thank you, Mr. Russell. Thank you, Mr. Pichardo. Thank you, everyone, for tuning in. Enjoy the rest of your week. See you same time, same place next week.